Perkins.
Hey, police report, Karla Perkins on behalf of the department. This is a case where we have a mother who was living in a home that she said she was one of 3 wives with a number of children. We have a case where this mother got a domestic violence injunction, and we had numerous reports called into the department, and actually our investigative summary shows that
none of this is pertinent to the issue on certiorari, which is the mother files an action against herself, and then they agree that the kids are dependent as to her, and therefore then the trial judge orders the department to get into the case even though it's not a party.
Correct.
And your arguments are that it has absolutely no authority to do any such thing, that there is really no case of controversy as to this, and that it's an abject violation of the separation of powers. Aside from that, it's a cool order. Maybe under the Monroe County or the Monroe Doctrine, there is such authority, but none in the United States Constitution or the Florida Constitution.
Thank you, Judge. I think I will reserve whatever other time for rebuttal.
Well, I have a couple questions if I might. This is a petition for writ of cert, right?
Right.
You're not appealing the merits of the judge's determination with regards to dependency, correct?
Absolutely correct.
Simply whether or not a trial court has the authority under the statute to order DCF to prepare a case plan in a private cause. Well, no, hold on. Where DCF was not an original party to the petition, right?
But
has the court ordered that services be provided yet?
Judge, I have to tell you that the case plan is about services, and
I
pointed out right off that the very first line in terms of the statute says the case plan is regarding provision of services for the child, and then that would also entail services for the parent because it's to, rehabilitate a person.
The guardian ad litem moved to require a case plan. That's why we're here.
Absolutely.
Right. And do you have a case that supports the proposition that the court does not have the authority to order DCF to create a case plan where a private cause of action or a petition not involving DCF has been filed? Do you have a case that supports the proposition or that construes the statute in such a way that DCF has no such obligation?
I can tell you, I've found no case that deals with that because the cases that I've found, which I've referred to as Falk versus Falk, which is out of this court at 649, 312, 1995 from the 3rd. Also GM versus JDM, which is 814, 1112, and that's out of the 4th TCA 2002. And that case specifically, and I think that case actually brings light to your question, where even though we don't have that case, the court specifically said, we hasten to add that the state is not a party in these proceedings. The DCFS did not recommend removing the child from his father's home. Thus, this litigation is between the family members, just like the custody proceeding in Dade County. I think that case actually answers your question as to whether there should be something else. Because, in private cases where you have one parent against the other.
Well, the private cases are somebody versus somebody else.
Absolutely.
This is ludicrous. This is like the lady walking into a 7-Eleven and saying, my kids are dependent as to me, and then calls up the DCF and says, you're required to give a case plan because I just admitted it. There's no case or controversy in this issue.
Well, that's what the state's interest is. The state's interest is in the children, correct?
Absolutely.
But it's up to
the children. It is the children who are declared dependent, correct?
Absolutely.
And the statute says that a parent or the department can file a petition, correct?
This is any person actually.
Any person who has an interest or
Correct.
Any person can file a petition, and at that point, if the conditions are met, then a dependency order is issued.
Right.
And it's at that point that a case plan ordinarily is done, correct?
Right.
And the statute says that the department shall prepare a draft of the case plan for each child receiving services under this chapter. And if you have a dependency, somebody's got to get services. Otherwise, there's no reason for dependency, right?
How did the finding of dependency come about in this case?
It's the mother. Well, it's the mother not showing up.
The mother brought the action and then didn't show up and therefore conceded to the action.
The case is about protection of the child, and
yes.
CR out of this court actually says the children have already been protected. You know, if we file the petition,
have been protected. Are you speaking about the? I know you are, but speaking about the domestic violence order, is that what you mean when you say the children are already protected?
Out of this court is the CR case that said the parents had already separated because the facts are the mom had already taken the children and moved out of the home and relocated, and the fact that she had the temporary restraining order, which should have been a permanent one.
Did the department, let me ask you this, Ms. Perkins, did the department know at the time this petition was filed by the mother that it was filed? Was it put on notice?
That I don't know the answer to. I would guess.
You don't know
because usually the department's lawyer is usually in court, so I would guess. I mean, I don't see.
Well, I mean, quite apart from that, is there any record evidence that at the time the petition was filed by the mother that it was provided in any fashion to the department so that they would know this mother is doing this? You know? You may not know.
I can't tell you that I recall that from the record.
So if I understand your position, if there is a petition that's been filed and DCF is not joined in that petition or filed it on its own, DCF should have the unfettered discretion to determine whether or not a case plan should be drafted? Is that your position?
No.
Okay, so tell me under what circumstances would DCF be subjected to an order to prepare a case plan in a private cause of action?
In our circumstance, or in any circumstance,
right.
Once the department gets called into the abuse, because that's the way the department's role is really triggered. That's how the legislature mandated the department's role to be triggered in a case. So once a call comes into the abuse hotline, the department is mandated to investigate.
Okay.
Upon that investigation, if they find nothing,
they did investigate. They did investigate and found nothing and decided not. This is like the trial judge ordering the state attorney to file a criminal complaint.
The difference is, in this statutory framework, there is a private cause of action. There is no analogous provision allowing a private cause of action in criminal law. So the legislature has spoken and has said, any person with knowledge, it doesn't even have to be a parent. It can be a third party who simply has knowledge of the need for this petition can file. So what I'm asking you is this. Are you suggesting that DCF has the independent right to conduct an investigation, and if they determine that no case plan needs to be prepared, they can tell the court in the face of an order directing a case plan be prepared under a private cause of action, Judge, we've done our own investigation. We decline to prepare a case plan. Are you suggesting that separation of powers gives you the right to do that?
But what you're saying is not the way it actually works.
I'm asking you.
It's not the department going in and telling the court.
That's the way it worked in this case. Well, the department decided that it had done an investigation, that there was no need for department intervention, and despite the fact that the court found that these children were dependent upon the state said we don't have to take action.
The court found the children dependent, but placed them in the mother's custody. They were never ever placed in the department's custody.
Well, whoever's custody,
would that have made a difference?
Yes, because whoever has the legal custody, I pointed out in my thing the definition of legal custody. Legal custody is whoever. Whether the child is given to the department, we are the legal custodians of the child.
So
if the child is given to the parent is responsible.
Still provide services.
So no case plan would ever be provided under those circumstances?
I will tell you, I've never seen a case that says that we have to do that. The cases that I've seen that are out there that address private petitions where a husband is fighting a wife or a wife is fighting a husband, found out of this court also was clear on the fact that to use the department at one parent's attempt to thwart the other parent. I mean, the mother actually appended in her thing Exhibit 1, a settlement agreement from 2005 where the father was to get custody of these children.
But that's not what you raised. That's not what you raised below. You didn't raise below that's being misused.
Counsel, excuse me. Counsel, you know, this kind of stuff is quote unprofessional. Go ahead.
I'm sorry, you were saying something, Judge.
Counsel, let's hear from your opposing counsel. We'll give you 2 minutes for a puddle.
Okay.
Good morning, Your Honor. Hillary Kambour for the Guardian Ad Litem program and Bernadette Restivo for the mother. I would ask that Ms. Restivo be given, split my time evenly with Ms. Restivo.
All right.
Your Honor, the underlying adjudication of dependency, the court clearly understands, is not at issue. The department was notified of the underlying dependency. They did not participate. They did not object. They did not argue this is a private matter.
They were notified of the underlying. Is there record evidence that they were notified and when they were notified?
Your Honor, Ms. Restivo can speak to that. She actually served the department attorney with the petition.
Is that in the record?
I don't believe it is in the appendix.
That's all right. We'll
yes. So the department had the opportunity to raise all of these issues about it being a private matter at the trial level and did not do so.
Why would they? Nothing was happening insofar as they were concerned. It was entirely a private matter. It was only when they were ordered on your motion to provide a case plan that they got an interest in the case.
Be that as it may, Your Honor, the issue before this court is not the validity of that adjudication of dependency. It's an interesting question whether or not the court had the authority to adjudicate a dependency in this situation. It's not.
Is there any subject matter issue there?
No, Your Honor.
Why isn't there? There has to be a case and controversy. A case between the mother and the mother is not a controversy.
Well, Your Honor, first of all, just factually, the mother also charged the father
but the father denied it, and there's been no adjudication of dependency as to the father. Is that correct?
Yes, it has not gone to trial yet. But also the Guardian Ad Litem joined the petition as well, having done an investigation for some 8 months, including paying for evaluations of the children. Once the child is adjudicated dependent, and I want to emphasize what the definition of that is, it has nothing to do with custody. Your Honor, pursuant to 3901, the definition sub 15 of a child who's found as dependent means a child who's found to have been abused, abandoned, or neglected. It isn't a child who's been placed in state custody. That's not the definition of a dependent child. The statutory scheme, I think Your Honors understand, is such. The legislature determined that anybody, the entire community, has a responsibility of looking out for children's safety.
But it's got to be a third person, doesn't it?
No, it says any person with knowledge of the facts. That's the statutory scheme.
DCF can either choose to intervene or not intervene.
Absolutely.
Now here's my question.
Yes, sir.
If there's an adjudication of dependency, does DCF have an independent right to appeal that even if they didn't intervene?
That's an interesting question, Your Honor. I don't know. Honestly, the answer is
if they don't, then we have a problem because they have no remedy then.
I believe that they could have. They were served with the petition,
but they didn't intervene, so they're not a party.
But if they choose not to intervene, now had they chosen to intervene and been denied, then they would certainly have a case.
But if they did not intervene, then you're saying they have to live with whatever the outcome is.
But they didn't intervene. They were just named and served. They're not a party by doing that. I can serve you in this case, and you said, I don't care. Leave me alone.
But this creates an even bigger problem because the more outlandish the allegations or the more unsupported the allegations, even if let's say DCF conducts its own independent investigation, they say there's nothing here. Mm-hmm. You're suggesting that their only way to protect themselves from expending their resources is to intervene in even the most outrageous and unsupportable petition.
Yes, Your Honor.
So that means expending other resources to avoid an adjudication of dependency that they think is unsupported in fact or law, only to be able to retain the rights to appeal an adverse adjudication.
Arguably, Your Honor, this is exactly what the legislature contemplated.
That makes no sense.
Well,
Because otherwise, they all they have to do is object.
Counsel, and I will say that in a very large number of ordinary divorce cases with children, one side or the other has called DCF and said the other guy or the other lady is abusing the kid. I want you to intervene. And in fact, that's what happened in this case, in this very case. And the lady herself says, I just wanted to get the DCF to pay attention to me. Wait just a minute. And the DCF goes in and says, this is a matter between the two of you. This is not a matter in which the state is concerned. You are saying that in every such case, in every such divorce case, the party aggrieved files a dependency action. The state has to come in. The court has, and if the mother agrees that or whoever it is, agrees that the children are dependent as to the party who brought the action in the first place, the trial judge has to get the DCF in and has to order a case plan because the child has been declared dependent as to the parent who brought the action. This is absolutely absurd.
Except that a court can deny accepting a consent. If the court felt there was being a fraud on the court in bringing this dependency, then it could have denied the consent. It conducted a policy. In fact, this court conducted an 8-month investigation into the situation concerning
the trial court.
The trial court.
So why couldn't it?
It appointed the guardian ad litem program to the case.
And the guardian ad litem
investigated.
And the guardian ad litem supported the dependency idea.
Let me ask you that. Suppose the guardian ad litem had refused to order it. Does the trial judge have the authority to appoint you? The answer is no.
Well, actually, that's an interesting question as well, Your Honor.
So it's not interesting anymore because the legislature has changed the guardian ad litem program from an officer of the court to an officer of the legislature as a part of the executive branch, and the 2nd District just held that very recently, as you, I'm sure, know. So they can't order you to appear.
The department doesn't have an interest in it until such time as it is ordered, till after the dependency, or perhaps after the dependency, when the department either by statute has an obligation or by order has an obligation. At that point, there is, in fact, a case in controversy, and the department can argue whatever it wishes. But this case says it presents the issue of whether the trial court has the authority to order it.
Yes, and Your Honor.
What case do you rely on that says, in a sweetheart case such as this, the court has the authority to order the DCF against its will to appear and expend funds?
Your Honor, there is no such case.
There is no such case.
Statutory scheme.
There is no such. Don't you think there's in every such case, in 25% of the cases that I have sat on as a trial judge in the family division, one side says the other is abusing the kid and calls the department. The department comes up and says, what are you talking about? This is a private matter. We don't want to get involved. You have a lawsuit. You have a divorce case. The trial judge can do whatever he did. What relief is being sought here that could not be and is not being available as a result of the actions in the divorce case or the restraining order issue?
Sure. I'm going to let Ms. Restivo speak to that. I do want to make one final point.
That's right.
I'm going to have her answer that question. Your Honor, if I just make one final point. The legislative scheme contemplated the community, the Department of Children and Families certainly, but the community at large being able to bring the matter of a dependent child
Do you
to the
think
court.
that is one of the parents suing herself a member of the community at large?
It is a person with knowledge of the facts, which is what the statute says. Then the statutory scheme says that if the child is adjudicated dependent, whether it's by consent or by finding or by failure to appear, a case plan must be be developed by the Department of Children and Families. And the statutory scheme contemplates no one else.
I filed a case against myself that's saying my children are dependent on me. And I agree. And the trial judge files an agreed order, the filing that the kids are dependent as to me. The department must file a case plan.
Your Honor,
that is ridiculous.
The court can refuse to accept a consent if it believes that there is a
Kambour, let's hear from Ms. Restivo. Ms. Restivo, Ms. Kambour went on a little more than 5 minutes, so we'll give you 3 minutes.
Thank you, Your Honor. The distinguishing point in this case, it's not a divorce case. This is a case where a family was living in a commune, 3 quote-unquote wives, 8 children, 1 man. My client was the wife in the home for the longest amount of time, and during the most brutal abuse that you can imagine. She filed a petition during an open investigation of DCF, prior to DCF stating that there was
after she had left. She had already left with the children.
She fled with 3 children. 4 children remain in that house today.
She fled with her biological children.
That's correct. She left with her biological children.
She filed a dependency action relating to those 3.
To all 7. This dependency petition went against all 7 children and against all 3 wives and husbands.
Then there's not been a finding of dependency as to the other 4 children.
That case has not gone to hearing yet.
There is no dependency.
There's no
dependency. There's a dependency as to 3.
As to the 3.
All right.
Yes. I think you just got me off track. What we had was with DCF having one investigation in July of 2010.
They're saying that there is at least no longer any problem as to the 3. That the petition was filed, that the wife had left the house with her 3 the 3 that the present petition pertains to, and that there's the department saying there's no reason for services. In fact, we have a domestic violence order, and that would take care of any problems there may be.
The department closed the door so early in this case, there was no way for them to determine the amount of psychological or emotional harm.
Well, you're complaining about the actions of the department. The department is an executive agency. You can't interfere. You can't, like saying the state attorney looked at this case and found that there was no murder, and they had no right to do that.
My client came to the court and said, I need help. I need help for these children. I need help for myself. These children have been brutalized, and they have witnessed brutal domestic violence. We need services. And she came to the court for help.
What services right now, today? What services do you want the DCF to provide?
If there were a case plan, Your Honor, we would ask that they follow the recommendations of the court on psychological evaluation.
There has to be presence, abuse, neglect, or abandonment. DCF doesn't get involved simply to provide services to people who need services.
There's services for victims.
You must have a statutory right to those services under one of those 3 areas that Ms. Kambour pointed out.
Oftentimes, case plans give services to victims of the domestic violence, victims of emotional and psychological abuse. These children, by the report of Dr. Wunderman, have been damaged. They need services, so they're not...
So, this is getting even, in my opinion, this is getting even worse. What you are saying is that everybody out there, every person every child who is being abused anywhere, who is not getting enough to eat, who is being dependent, I can bring an action against, independently of anything, the child is dependent, and you get the DCF in on every single case of every single abused or dependent child.
Or any problem a child has in the state.
I'm sorry, Your Honor?
Or any problem a child has in the state, whether it's not getting enough to eat or having a psychological problem.
If a parent comes to the Department of Children and Families, and I understand this is the converse of what we normally see, and there's a situation that's so abusive
you can walk in, and, well, okay. All right, Counsel, let's hear from Ms. Kambour. Ms. Kambour, we'll give you 2 minutes. Perkins, I'm sorry. Ms. Perkins. Ms. Kambour's usually on that side. Usually Ms. Kambour and Ms. Perkins are together.
I always thought you were the same. I thought that, it's nice.
They are.
It's amazing what modern medicine can do to separate previously conjoined persons. So without even leaving an apparent scar.
We'll still give you 2 minutes, Ms. Perkins.
Would you agree that if you all had intervened in the private petition, that you would have been able to participate in the hearing and preserve your right to appeal the merits decision by the trial court?
Let me answer it this way, if I may. If we had found the grounds to file the petition, we would have done the work ourselves. We wouldn't have needed to have this mother do this, but our investigation showed that it would be a bad thing.
That's not what I'm asking you. I'm actually asking you the flip side of that. In other words, you saw the petition, you get served with the petition, you say, look, we already did our own investigation. We need to intervene because we do not believe there should be an adjudication here. We don't want to spend our resources to provide services for somebody on allegations that we believe are unfounded. So it's not because you believe that they were supported. I'm asking you, did you all have the authority to intervene as a party to object to the adjudication on the merits and participate in the hearing leading up to the merits decision? Did you have that right?
The department's not going to intervene in private petitions like that.
You don't have the authority to do it?
How could we have the authority?
I'm asking you.
The legislature has set up how the department becomes involved in a case, and it's through calling into the hotline and then we investigate.
So you have no right to intervene in a private petition.
Don't intervene because if it's the father fighting the mom, we're not going to do that.
I didn't ask you if you do or don't. I'm asking you.
The department would not.
Under the statutory framework, do you have the right to intervene? That's what I'm asking.
I don't see that in the statute. I see the statute the way the department is involved.
Even if you did have the right to do it, if you say what they're saying is that you must do it. There can't be any possibility of that. You're not required to do something in order to avoid something which has no authority in the first place. You can assume that the court is going to follow the law. Unfortunately, sometimes that assumption is not well justified.
Thank you, Ms. Perkins.